Hi, my name's Stuart, and today I'm here to talk to you about the changes in the occupational health and safety legislation to come into effect as of the 1st of January 2012. This presentation is part of the Work Health and Safety Workshop developed by Surf Lifesaving New South Wales. I'll only be talking about the Work Health and Safety Act as the Workers' Compensation Act is separate, and therefore it's not affected by the changes. The aim of this presentation is for you, our members, to gain a thorough understanding of the new work health and safety legislation and how it will affect your club. Okay, so let's get started. Firstly, you may be thinking to yourself, what are the changes to the Act and why is it changing? On the 1st of January 2012, the new Work Health and Safety Act will come into effect to replace the current Occupational Health and Safety Act. This will create a high level of consistency in work health and safety throughout Australia, as the new legislation is being mirrored in each state and territory. Let's ask some of our members why they think complying with health and safety legislation is so important.
To make sure all our members are aware of health and safety issues, and so we don't get fined.
Everyone has the right to a safe workplace.
To reduce the risk of injuries in our clubs and during events.
If your club is complying with current legislation, following Surf Lifesaving New South Wales and Surf Lifesaving Australia guidelines, and taking reasonable care for your own and other people's health and safety, then you probably won't have to make any changes. And the changes in the new Act will probably not affect your day-to-day surf lifesaving activities. We're going to start by going through some new terminology that has been introduced in the Work Health and Safety Act that you may not be familiar with. Firstly, the term employer is now replaced by PCBU, meaning person conducting a business or undertaking, and they are the holder of the primary duty of care. Whether the business is conducted for profit or not for profit does not affect this. Workers now replaces the term employees. A worker is broadly defined to include anyone who carries out work in any capacity, including an employee like a paid admin person, a contractor like an electrician or bus driver, and volunteers, including surf lifesavers. All workers have a duty to take reasonable care of themselves and others while at work. An officer is a person who makes or participates in making decisions that affect the whole or a substantial part of the business. This may include a person on the board of directors or a committee member that participates in the decision-making process. Others are now also included in the Act and consists of anyone around the workplace who isn't a worker or other PCBU. This may include visitors to the surf club, the public using the beach, passers-by, or even when you're not working as a volunteer. Although they have limited control, others still have to take reasonable care of themselves and others around them. Two of the new and most frequently used terms in the new Work Health and Safety Act are reasonably practicable and due diligence. Reasonably practicable represents what can reasonably be done in the circumstances. It is based on what a reasonable person could be expected to do. Reasonably practicable takes into account the level of risk, the knowledge about the risk, and the availability of ways to eliminate or minimise it. Due diligence means taking reasonable steps to keep up to date on work health and safety matters, gain an understanding of risks in the workplace, and make sure resources are used to eliminate or minimise those risks. Communicate regarding hazards in the workplace and respond in a timely way to that information, and implement processes for complying with work health and safety duties. The current OH&S representative will now have the option of taking on the position of Health and Safety Representative, or HSR, and will have more functions. An HSR can direct unsafe work to cease. However, this power is subject to limitations. It's not compulsory for your club to have a HSR unless a volunteer or worker requests one. So let's go back to one of the members that we were talking to earlier and see if they classify themselves as a worker.
Well, I see myself as a volunteer. I mean, I don't get paid.
Well, in fact, under the new Work Health and Safety Act, a volunteer who is engaged by a PCBU is now entitled to the same protection and responsibilities as any other worker. But what does this actually mean for you? And how will it impact your day-to-day surf lifesaving activities? All this means is that just as any paid worker, a volunteer must take reasonable care for themselves and others, comply with reasonable instructions from the PCBU, cooperate with policies and procedures of the PCBU. A worker who fails to comply with health and safety duties commits an offence and, if proven guilty, can be prosecuted under the 2011 Work Health and Safety Act. But don't worry, all you have to do is exercise reasonable care for yourself and others and comply with policies and procedures. If you and your club are following Surf Life Saving Australia and Surf Life Saving New South Wales guidelines and taking reasonable care for your own and other people's health and safety, it is likely you will already be complying with the new Work Health and Safety Act, and your day-to-day surf life-saving activities should not be affected. Remember, we mentioned earlier that an officer is a person who makes or participates in making decisions that affect the whole or a substantial part of the business, and may include a person on the board of directors or a committee member. Well, all officers must exercise due diligence to ensure the surf club meets its duties and obligations under the Work Health and Safety Act. However, if you are a volunteer officer, you can't be prosecuted for failing to meet officer duties. So committee and board members are not at risk of being held liable for the actions of other volunteers. Although, you can still be held liable for not complying with your duties as a worker or other. Health and safety is everyone's responsibility, and duties should be taken seriously, not just in leadership roles, but by all members. It's important here that everyone knows if we fail to meet workplace health and safety obligations, we are breaking the law. As you can see by the table, there are 3 categories of penalties that apply to breaches of work health and safety duties. A Category 1 breach means committing reckless conduct that exposes an individual to a risk of death or serious injury or illness and is engaged in without reasonable excuse. A Category 2 breach includes failure to comply with a health and safety duty and exposing an individual to a risk of death or serious injury or illness. And a Category 3 breach covers failure to comply with a health and safety duty. These breach categories have always existed. However, the size of the maximum penalties for each type of duty holder has increased from the existing OH&S Act. But again, remember, as long as you and your club are already following Surf Life Saving Australia and Surf Life Saving New South Wales policies and procedures and taking reasonable care for yourself and others, you shouldn't have to change anything to stay compliant. By complying with work health and safety in your club, there is every reason to expect that workers and volunteers will go home safe and sound. However, offences may result in work cover intervening and taking appropriate action to prevent people being placed at risk. This may include penalties for serious offences. The maximum penalties have increased considerably from the OH&S Act, showing that there is now a greater importance being placed on the need to make sure people are not placed at risk of work-related injury or illness. Any prosecution action will now have to prove that the PCBU or the individual being prosecuted has committed an offence. In the OH&S Act, it's the opposite. You have to prove that you did not commit an offence. This is one of the many benefits of the new legislation. Research indicates that a safe workplace is best achieved when workers and those responsible for undertaking and managing the work talk to each other about potential problems and work together to figure out the best solution. By drawing on the knowledge and experience of each other, more informed decisions can be made about how work can be carried out safely. PCBUs have a duty to consult more openly with other workers and PCBUs at the workplace. So, for example, surf clubs will have to consult with contractors undertaking work on their behalf, or councils, etc. And in fact, this may already be happening in your club. The only difference is, it's now included in the Act. Lastly, the new Work Health and Safety Act makes consultation between all parties a legal obligation. If you have an issue with work health and safety, what would you do?
Well, I can't do anything about it. I'd have to tell the health and safety rep, who would then bring the issue up in a club meeting.
That may have been the process within the OH&S Act, but in the new Work Health and Safety Act, anyone, yes even you, can bring an issue regarding work health and safety to the attention of management or the Work Health and Safety rep, not just an HSR or committee. All matters raised must be taken seriously and dealt with in a professional manner. Now, if you do have an issue, start by discussing it between the parties. For example, let your club captain know and see if they can help you get the issue resolved. If you're not satisfied with the solution or can't come up with a solution, there is a default procedure outlined in the regulations. If you still can't come up with a solution, you can apply for a work health and safety inspector to help. When identifying an incident, it is important to recognise there are 2 categories of notifiable incidents: serious injury or illness and dangerous incidents. So why is it important to identify and follow the correct procedures when notifying an incident? The purpose of incident notification is to enable work cover to investigate serious incidents and potential work health and safety contraventions in a timely manner. So what then is considered to be a serious injury or illness? The Work Health and Safety Act defines a serious injury or illness as requiring the person to have immediate treatment for an injury including inpatient in hospital, amputation, serious head, eye or burn injury, spinal injury, loss of bodily function, serious lacerations, or treatment within 48 hours of exposure to a substance. For example, in a surf club environment, if a lifesaver was to suffer serious spinal injury as a result of slipping down unsafe stairs, this would be considered to be a notifiable incident. What is a dangerous incident? The Work Health and Safety Act defines a dangerous incident as an incident in relation to a workplace that exposes a worker or any other person to a serious risk to a person's health or safety emanating from an immediate or imminent exposure to escape, spillage or leakage of a hazardous substance, implosion, explosion or fire, electric shock, escape of gas or steam, fall from a height of any plant, substance or thing, structure collapse. In a surf club environment, if there was a function being held and a large fire was to break out in the kitchen causing the building to be evacuated, this would be considered a dangerous incident. Under the Workplace Health and Safety Act 2011, PCBUs are required to preserve the incident scene until an inspector attends or directs otherwise. In the case of an incident occurring, it is important to know who to report it to, as well as the correct procedure for notification. So what does the Act say PCBUs must do? Under the Act, notifiable incidents involving the death of a person, serious illness or injury of a person and dangerous incidents, that is, incidents that expose persons to serious risks at a workplace, must be reported immediately to work cover by the PCBU. It is also a requirement under the Act for persons with management or control of the workplace to ensure, so far as is reasonably practicable, that the site of the incident is not disturbed until an inspector arrives or as otherwise directed by an inspector, unless of course someone is in immediate danger. So what is the correct procedure which should be taken to report an incident? The most effective procedure for reporting an incident consists of 3 steps. Step 1. Notify work cover by quickest means possible, either by phone or in writing. Step 2. Ensure the incident site is preserved until an inspector arrives. The new 2011 Work Health and Safety Act will be introduced on 1st of January 2012. Step 3. Keep a record of notifiable incidents for 5 years. Surf Lifesaving must strive to achieve a culture of safety, which is a legal requirement and a moral duty of those in leadership positions. So in summary, the main changes we have gone over today include the new Work Health and Safety Act will be introduced on January 1, 2012. The terms PCBU, worker and HSR have been introduced and the meaning of officer has changed. Volunteers are now included in the Act as workers. More consultation responsibilities exist. Everyone now has a duty to consult with PCBUs, workers and others in the workplace. The issue resolution process is now defined. Notifiable incidents have changed and the incident scene must be preserved until an inspector arrives or directs otherwise. The main thing to remember is if your club is complying with current legislation, following Surf Lifesaving New South Wales guidelines, taking reasonable care for your own and other people's health and safety, it is likely the changes in the new Act will not greatly affect your day-to-day surf lifesaving activities. Listed here are the guidelines for safer surf clubs from Surf Lifesaving Australia. They are available in all clubs as well as in the Secure Resources Library on the SLSA website at www.slsa.com.au. Here is a list of other resources that can be used to access information regarding Surf Lifesaving Australia health and safety policies and procedures. All these resources should be available in your clubs. If any of them aren't, please let Surf Lifesaving New South Wales headquarters know so we can get them to you as soon as possible. If anyone needs more information, here are the contact details for Work Cover and Safe Work Australia. They have operators who are trained in all areas of the Act and are very helpful. And finally, here are the contact details for Surf Lifesaving New South Wales headquarters.
It is important to remember that health and safety is everyone's responsibility, and by working together we can ensure Surf Lifesaving New South Wales provides a culture of safety and minimises injuries within the workplace.